Hello, my name is Christopher Millard. I'm Professor of Privacy and Information Law at Queen Mary University of London, and I'm Senior Counsel to the law firm Bristow's. I want to talk today a bit about the emergence, or at least proposals for regional clouds and even national clouds, and in particular, I want to talk about the implications of a possible Europe-only cloud. But first, a little bit of context. In a previous presentation, I went into some detail on what cloud computing is, why it's having a significant impact on markets and people's daily lives indeed, and what some of the key legal and regulatory issues are, including some of the contractual issues. I'm not going to go over that again today. I just want to very briefly set the context by suggesting that a simple way of thinking about what cloud computing is that it's online, scalable IT resources on demand. So online, typically delivered via the internet. Scalable means you can use as much or as little as you want. IT resources could be as in computer processing facilities, it could be storage, it could be a number of different, many different software services. And on demand means that you can access it whenever you are connected to the internet, and in many cases you can use certain features when you're offline as well. Computing as a utility is one way of looking at it, and a popular analogy is with electricity, which until about 100 years ago people had to generate themselves in corporations and government agencies and so on, whereas today almost everybody buys almost all their electricity from a grid from a third-party supplier. And there are suggestions that that's the way that actually computing is going to go pretty soon. Now there are various drivers for this move towards cloud computing, including promises of substantial productivity gains so that you'll be able to do things better, maybe be able to do things faster, more efficiently. But also cloud is a key enabler, and this is one of the big reasons why it's growing so fast at the moment. It's a key enabler for many mobile platforms and apps, and it's used widely to provide services such as email, social networking, as well as the new craze in quantified self and health and fitness tracking and so on. It's used for big data analytics. It's going to be vital in enabling the deployment of the Internet of Things, which is a very interesting development that's already well underway and is probably about to explode in terms of scale and reach and significance. Now, many of the benefits of cloud are already beginning to become clear. But this very dramatic growth in the take-up of cloud computing is proving to be a bit disruptive for various reasons. Technically, it's really challenging many of the assumptions that have been made for decades about how computing services should be delivered and procured. It's also, for that reason, disruptive commercially, because many of the players who were well established in the more traditional computing market are now finding that actually they have to reinvent themselves in many cases as cloud companies. I would also say that the complex and rapid changes that are taking place in the context of cloud computing can be unsettling for providers of services, customers, end users, including consumers, and, of course, legislators and regulators who are generally a few steps behind in terms of keeping up with the implications for society of new technologies. A lot of the concerns relate to data protection compliance, including questions of transparency. Do you really know where your data are, what's happened to your data? Questions of control, particularly where you have a complex cloud delivery ecosystem with multiple service providers who may be dependent on each other and may not be clear to the ultimate user of the service who has control of what at a particular time. Security is a widespread concern. And, of course, the confidence in cloud computer services hasn't exactly been helped by the recent disclosures, the recent revelations, you might say, of widespread systematic industrial-scale surveillance by government agencies. So there's a lot of talk about whether it's safe to put your data in the cloud. I'm not going to go into that in more detail right now, but I want to turn to this specific question of whether geography still matters. And even though the internet is a global network of networks, I would argue that geography has always mattered, it still matters, and it probably will continue to matter for quite a long time. And geography and jurisdiction and control, these issues are at the heart of today's topic of whether there could be such a thing as a Europe-only cloud, what that would mean, whether it would make sense, whether it would be permissible even from a legal and regulatory point of view. Now, just a bit of history here on European attitudes to personal data and data protection. Concerns in Europe about these issues are long-standing. I'm going to give you a quote from the 1970s and I will give you the quote unedited. Here it is. We do not really trust the data acts in other countries, or we feel that there are none at all. So we feel unprotected in those countries with our data, walking down Fifth Avenue in our underwear. Pretty graphic way of portraying the risks of moving your data to a country like the United States. That's back in the late 1970s. The person who said that was Kerstin Amer, at the time an undersecretary in the Swedish government, and she said it as a justification for the world's first national data protection law, which was a statute that included a requirement that prior authorization should be obtained for exports of personal data to places like the US. Now, these arguments, if you fast forward to the last couple of years, have, you might say in today's jargon, gone viral, but they've certainly gone beyond concerns between the EU and the US. And I want to give you a very recent quote from a statement that was made in the Russian parliament by Russian MP Vadim Dengin. In his case, he was justifying mandatory local storage obligations in Russia's new data protection law so that any information about Russians, and it's not entirely clear what that means, but let's just say Russian citizens, even if it is processed outside Russia, must be stored as well or only in Russia. And there's a lot of uncertainty as to what this law means in practice. And in the time before it comes into force, probably sometime in late 2015, people will have to work out whether that means they need to make copies or replicate all their database systems in Russia in relation to Russian customers, for example. But here's the quote. Most Russians don't want their data to leave Russia for the United States, where it can be hacked and given to criminals. Our entire lives are stored over there. So I think it's already becoming clear that although that there are some real and maybe well-founded concerns about the way in which personal data is handled by businesses, by government agencies and other bodies, this is rapidly becoming a political hot potato. Indeed, just to show you how hot it is, here's a quote from February 2015. When President Obama was asked in a television interview whether US privacy regulation had, quotes, any teeth compared to that in Europe, which is, quotes, very strong on these things, that's what the interviewer said, President Obama's response was, sometimes the European response here is more commercially driven than anything else. There are some countries like Germany, given its history with the Stasi, that are very sensitive to these issues, but sometimes their vendors, their service providers who, can't compete with ours, are essentially trying to set up some roadblocks for our companies to operate effectively there. So here we have the President of the United States stating that although he acknowledges there are some concerns in Europe, some of them historically grounded in as to what might be done with personal data, he's suggesting that actually data protection laws might be being used as an excuse or a smokescreen almost for other issues such as trade issues and to provide obstacles to American companies which, as he puts it, unlike European companies, really are leading in the cloud computing field, and these may be obstacles to them doing business in Europe. So just very briefly to close that overview of attitudes, the European Commission's prompt response to Obama's statement was, quotes, this point that regulations are only there to shelter our companies is out of line. Now, that was not, very considered or well-argued response. There was a more measured comment that followed up later, but it was fairly bland about saying, yes, we want everybody to be able to access services in Europe, and we want an open market. But it was very much an open market in Europe, not a call for global openness and freedom to do business and freedom to transfer data globally. So a key question, now we get into the meat of this, is can you actually control the location of your data when you put your information into cloud services of one kind or another? Now, I'm a lawyer, so the response you're perhaps expecting you're going to get, which is, it depends. Actually, it depends on quite a lot of factors. For a start, some service providers, some cloud service providers can't, for technical reasons, or they won't, for commercial reasons, give you a choice. Other service providers, though, are designing their clouds and have been doing for some years so as to offer customers a choice, at least between geographic regions such as North America or Western Europe or Asia and so on. And in some cases, they're getting more granular than that, and they're giving choices right down to a server farm in a particular country. Geolocation, of course, can be a critical issue for customers that have specific regulatory obligations, such as companies in the financial services sector, where their local financial services regulators are going to want to know where data is stored. They may actually want to be able to conduct audits and so on. It's also important, of course, where there are political sensitivities. So governments may feel that they need to reassure their citizens that certain types of public sector data will be stored and otherwise processed locally. And it's also important in terms of compliance with data transfer rules in data protection laws. And for example, under the EU Data Protection Directive 1995 and the national laws implementing that directive, there are restrictions on transferring personal data from a country in Europe to a place outside the European Economic Area unless it is on a very short list of approved countries, and you have to then take steps to justify those data exports. So that suggests you need to know where your data will be going to. And another reason why geolocation is becoming increasingly important is in terms of disclosure risks associated with litigation and requests from law enforcement authorities, and there have been many high-profile examples of that in recent years. A case that is ongoing involves a request by a US magistrate, or authorization by a US magistrate, I should say, of a search warrant relating to webmail stored in a server farm in Dublin. And Microsoft, who happens to be the cloud service provider, is resisting this, and so far has challenged it at 2 levels in the US, and is likely to appeal this at the moment, it appears, a lot further, because there's a lot at stake, really. If a US magistrate can authorize a search warrant compelling a US cloud service provider to retrieve personal data from anywhere on the planet where it might have a cloud service facility, then that raises significant conflict of laws issues, and it bypasses established methods for cooperation between countries in terms of law enforcement disclosure access requests. In Europe, meanwhile, we are seeing data location not just being talked about by regulators, but being talked about by cloud service providers and framed in terms of a competitive issue. And I'll give you a few brief examples here. This one is from Deutsche Telekom. Quote, "Telecom ensures the greatest possible protection of customer data thanks to high security standards complying with German law. In comparison, the data at cloud locations in other countries can sometimes be accessed by government bodies. The advantage Telecom offers, customers themselves can decide where their data is to be stored." Here's another example from BT, or British Telecom, as it used to be called. "BT Cloud Compute is designed to help Chief Information Officers meet their stringent compliance requirements and local law and regulatory obligations by letting them decide exactly where they want their sensitive data to be hosted." And my favourite European example at the moment is a rather small startup company in Oslo called Jota Cloud. And they make, I think, the most lively and feisty statement I've seen to date about cloud localization and how that can give increased protection. So here's a quote. "Jota Cloud is a Norwegian cloud storage service for both private use and businesses. The service lets you securely copy, synchronize, save, and share files from all of your devices. These files will be safely stored on environmentally friendly servers in Norway or in countries with equivalent or even more rigorous privacy laws. Firms based in the US might be forced to hand over their stored information to the authorities. No one will get access to the data stored with us." Now, that should make you feel good for a number of reasons, not least because you're using environmentally friendly cloud services, but the idea that you really can have this kind of guarantee that your data will stay in Norway, if that's where you want your data to stay. Now, there's a discussion to be had as to whether that is actually realistic, whether Jota Cloud is in a position to give that guarantee. That's for another day. But what I want to use that as an illustration for is how claims of regionalization, localization of cloud services are being used for competitive positioning purposes. Now, the idea that we might have a European internet is not new, and it predates the revelations by Edward Snowden about surveillance that I mentioned earlier. I go back to February 2011 is the earliest example I found. Now, the European Commission official has told me that he doesn't like me referring to this because they would rather really not draw attention to this particular bit of history, but I'm afraid it's a fact, and so far they haven't found a way of suppressing it. So here we are. This is a quote from the minutes of a joint meeting of the Law Enforcement Working Party and the Customs Cooperation Working Party. And under their heading Cybercrime is this record. The president of the Law Enforcement Working Party presented its intention to propose concrete measures towards creating a single, secure European cyberspace with a virtual Schengen border, remember that because I'll come back to that, and virtual access points whereby the internet service providers would block illicit contents on the basis of the EU blacklist. Now, there are a number of things that one could say about that could take up the rest of this presentation. But I just want to put that out there because this is the first example that I and my colleagues in the Cloud Legal Project at Queen Mary University of London have found of a proposal for a European cyberspace, they called it, with a virtual Schengen border and virtual access points. And we'll come back to what that might mean. Now, if you move ahead to the time since the Snowden revelations, in August 2013, Deutsche Telekom and United Internet AG, which between them I think provide about 2/3 of email services in Germany, started to talk about a service called Email Made in Germany. And meanwhile, Atos, a major outsourcing company, actually picked up on this concept of a Schengen system for data and said that would be a good idea and worth exploring further. In October that year, October 2013, Deutsche Telekom announced that it was working on a system for German-only routing of cloud traffic. And that's actually rather interesting because it raises questions then not just as to whether you're buying, say, an email service from a German cloud provider, but whether all the way down the stack, as it were, to the connectivity, the basic communications networking, whether that would also be kept within Germany. And if you read between the lines here, it's clear they couldn't actually do that, and they probably can't do it now either, because Deutsche Telekom, like other cloud providers in Europe, is dependent on companies in other countries for traffic routing purposes. And indeed, at the heart of the architecture of the internet is the idea that messages and packets of data and so on can be handed over from one network to another. That's why it's often called a network of networks. A month later, in November 2013, the German Interior Minister talked about developing a legal framework for hindering interception. Now, you have to realize the context here. There was a lot of anger in Germany at the time about revelations of apparent interception of phone calls on Angela Merkel's mobile phone, and the Snowden revelations were continuing to emerge and were causing, I suppose, you might say, shock and awe in political circles in Europe. The following year, in February 2014, there was a meeting between Angela Merkel and François Hollande where they talked about building up European communications networks, quotes, to avoid emails and other data passing through the US. So this is not just a flash in the pan, one-off idea, crazy idea from somebody that you could actually run a European cloud or a European internet. It's been discussed quite widely in a number of countries. But let's dig a little bit deeper. What on earth would a Europe-only cloud be? What would it look like? How would it work? Does it actually make any sense? I think it helps to break it down at this point into the constituent components. So we're talking about cloud, we're talking about Europe, and we're talking crucially about only. Okay, so let's take each of those briefly in turn. In terms of the cloud or a cloud, questions immediately arises, well, what exactly do you mean? What service model for cloud computing are we talking about here? Are we talking about infrastructure as a service, for example, the servers, the computers that you find in a cloud server farm, which other people can then run their software on and provide their services on? Or are we talking the next level up in terms of complexity of platform as a service, which might be a computer with an operating system and certain tools like security tools and so on, which again you can use to run your own services on? Or are we talking about the most developed layer of cloud services, the idea of software as a service, which would typically be a fully configured online service such as webmail or marketing or customer relations management software, or maybe an HR system and so on. And it does make a difference which of these layers you're talking about. And as I said earlier, you can dig even deeper right down to the fundamental network layer. And the discussions that so far have emerged on what a Europe-only cloud might be have tended to be extremely vague on this. But even if it was possible, notwithstanding the qualification I said earlier about even Deutsche Telekom not being able to keep all traffic in Germany, even if it was possible to have a Europe-only infrastructure and maybe Europe-only platforms for cloud services, then you still have to ask the question, but what about the fact that many of the most popular software as a service cloud services are in fact US-based or at least US-controlled? And indeed, quite apart from that, millions of businesses in Europe use websites and facilities that may well involve the use of US-provided infrastructure or platforms in the cloud. And I don't think it makes any sense for it. It doesn't pass the laughter test to say that suddenly all of these types of services would be banned. I mean, can you imagine the citizen response if the European Commission or the European Court of Justice or the Parliament or whoever was to try to close down and block access to Facebook, Twitter and other very popular services just because they were not part of a Europe-only cloud? And interesting, again, I mentioned President Obama's views on protectionism earlier. The reaction of the Office of the US Trade Representative to proposals for a Europe-only cloud have been pretty strong. One statement was that any mandatory intra-EU routing may raise questions with regard to compliance with the EU's trade obligations with respect to Internet-enabled services. So if you're going to try and keep European Internet traffic within Europe, geographically, jurisdictionally, then that raises questions about the EU's trade obligations. And specifically on the question of the idea of a Schengen area for cloud or Schengen routing, the Office of the US Trade Representative stated, this appears to be a means of providing protectionist advantages to EU-based ICT suppliers. So you can see this is going to be very contentious, and it's not an issue that's gone away. There are still calls for localization of internet and specifically cloud services. Let's turn to the second element. We talked about cloud. What do we mean by that? Let's talk about Europe. Now, this one ought to be easy. Most people watching this presentation probably think they know what Europe is. Unfortunately, it isn't quite that simple. There are several possibilities here. One is that you might just use European cloud providers, but then what's the test? Does that mean it's a company that's incorporated in Europe? Does it mean that it is, in data protection terms, established, or in tax terms that it's established in a particular EU member state? What's the test? And how far again down this stack do you go? Does everybody in the European cloud have to be European, however you choose to define that? Well, then maybe a second test would be that you would confine the physical location of data to Europe. But you might ask, well, what does that mean too? Location of what exactly? Is this the computers on which data may be stored? Is it the data centers, which are typically large warehouse type structures containing large numbers of cloud servers? Is it the data? Is it the people who manage the data? Is it the underlying networks? Another possibility would be to say, well, by Europe, what we really mean is you must process data only in accordance with European laws. This one, I think, is the most promising. It is by no means an easy solution to implement, but at least there is some scope for talking about it in some more depth. But even then, we have to go back to, but what is Europe? So if you say you must process data only in accordance with European laws, does that mean, for example, the laws of the 47 member countries of the Council of Europe? Bear in mind that the Council of Europe was a pioneer in establishing an international convention for data protection that is still widely regarded and widely used and has a growing number of countries ratifying it, including some outside Europe. Or do we mean perhaps the 31 member states in the European Economic Area, or do we mean the 28 EU member countries? At least at the time of recording, it was 28. We are all watching with great interest developments in various parts of Europe right now to see whether that number fluctuates, but probably down. Or do we mean, since this term Schengen has been bandied around, do we mean the 26 countries in the Schengen zone, the current free movement of persons zone called Schengen? That would raise interesting issues because there are a couple of significant countries economically and in terms of cloud services that are not in the existing Schengen region. And they are the United Kingdom, which is obviously a significant centre for for business, for financial services, and generally in terms of economics. And, interestingly, the Republic of Ireland, which is the most popular location for global cloud services companies to put infrastructure for Europe. Now, if those countries are not in the Schengen zone for cloud, what exactly would that mean? And how would you deal with conflicts of laws, even within Europe, however you choose to define Europe? Because laws on fundamental issues such as contracts, such as data protection, have not been harmonized effectively throughout the EU. Even though we have, for example, for data protection, a directive from 1995, there is significant divergence in the way that directive has been implemented in the national laws of the EU member states. And in some respects, that would affect the ability to move data freely, even within a Europe-only cloud. So there's plenty of scope for confusion here. And partly it's due to a conflation of concepts of physical location, access to data, applicable laws, and jurisdiction, and so on. Now let's move to the third element of a Europe-only cloud. This is the word only. There are problems here, as I've said, due to multiple applicable laws. And this is true even within Europe, and would be a problem even for a Europe-only cloud internally, because of the inconsistency between national laws within Europe. But also, of course, strikingly, once you start to look at connections between a Europe-only cloud and the rest of the world. And I don't just mean technical data connections. I mean, what if somebody outside Europe, however you define it, uses a European cloud? Or conversely, what if somebody in Europe wants to use a non-Europe cloud? And I think one of the challenges here is that when you start to look at these global conflict of laws issues, there's a risk that an attempt to provide, in an attempt to provide greater protection for European citizens, the byproduct, the collateral unintended consequence might be that there would be an enforcement or sanctions arms race. I mean, there are already signs of this, and there have been for some years now, in the way that the Data Protection Directive has been implemented. So many organisations, particularly businesses, find that they are caught between a rock and a hard place. On the one hand, they may get an order from a US court or a request from a law enforcement authority in the US to disclose information. And they may find that that is actually a legal obligation, and if they fail to do it, they may commit a criminal offence in the US. While at the same time, they may find that when they analyse the situation under the national law of the country where they are established in the EU, or indeed many countries, potentially all of the EU countries, depending on the circumstances of the case, that they have a legal obligation to not disclose or reveal the data, and that to do so might also be subject them to administrative sanctions or indeed criminal charges. Now, this could become a much hotter issue if the current proposal for a new general data protection regulation is adopted. The text is still not settled, and the Council of Ministers has some way to go in terms of working through it and coming up with its own counter-proposal to the proposals that have been put forward by the European Commission and by the European Parliament. But if you look at the existing complete text, and we do have some leaked Council text, but if you look at the complete Commission and Parliament texts, you see very tough sanctions in there for breaches of this new general data protection regulation, with fines in the Commission's text of up to 2% of global revenues, global turnover. We're not talking about profits here, global turnover. And in the Parliament's text, up to 5% of global turnover. Now, at that point, data protection compliance in Europe is elevated to the level of antitrust compliance for major multinationals, where this is a main board issue. The stakes are enormous. And if, meanwhile, you have American regulators, American courts, American law enforcement authorities demanding access to data, then you can see how this, between a rock and a hard place, becomes more than just potential for some temporary discomfort. Now, of course, there is a hypothetical solution to all of these issues, which is that we have an international agreement, maybe a new convention, and that all countries on the planet sign up to it and agree what it means, and then carry on happily ever after transferring data in a safe, secure, certain manner. Now, that is a pipe dream. I don't say that it's a bad idea. I just don't expect to see it for the foreseeable future, perhaps ever. So we are stuck at the moment with this complex picture of local laws in many parts of the world that are not consistent. And when you attempt to put a fence around a region geographically or jurisdictionally, you have to think about how you deal with these conflicts of law issues. So really I want to turn now to an even more fundamental question than the ones I've asked so far, which is why is a Europe-only cloud a good idea? Or indeed, why is it that companies and politicians and others have been promoting this concept in recent years? So on the question of why, I think really there's a problem here conceptually, because for the reasons I've just outlined, governments, legislators, regulators and others may be fundamentally mistaken. They may be making a kind of category error in assuming that physical location of data is the only important thing or even the most important thing. Now I could see why physical location matters to governments and regulators and courts, because there are certain things you can do if you have physical control over a person or a company's assets or whatever. So it does facilitate the enforcement of certain laws. So for example, if an operator of an online gambling service in Europe, which may be perfectly lawful in Europe, offers services to customers in the US where that online gambling service may be criminally illegal, then if an executive of that company travels to Florida on holiday with his family, he may find that he gets arrested at the point of entry into the US. Now that's a real case that's happened. There are many other examples like that. So in that case, the physical location of a director of a company was the opportunity for US law enforcement to arrest somebody. Turning the example around, let's say that a US company is doing business extensively in Europe and it has certain assets here. It may own properties, it may have equipment, buildings, whatever. Then if you want to enforce, say, a tax order against that company, it may be useful that you can seize physical assets or gain control over physical assets in Europe. Now, another possible reason why there is so much of a focus on physical location might be that there is a genuine concern about restricting foreign surveillance, particularly post the Snowden revelations. But a more cynical view might be when you look at some of the countries that are determined to have forced localization of storage about their citizens, maybe perhaps a little bit more skeptically one could say that a local or regional cloud might be very convenient in terms of facilitating surveillance by governments in that area or by law enforcement authorities in that area. Another possible reason why there's this big focus on geography at the moment might be to promote local or regional service providers. And the examples I gave of the marketing position adopted by some of the cloud service providers in Europe at the moment would seem to support that analysis. But I think physical location might be completely the wrong focus. First of all, physical access to data is neither a necessary nor a sufficient requirement to get access to intelligible information. And this is regardless of geography. So if I have a securely encrypted file on a device that I control, or indeed in a cloud service somewhere, anywhere on the planet, then merely getting physical access to my device or to the server in a server farm will not necessarily give anybody access to intelligible information. So that's a crucial distinction between physical and logical access. Whereas, of course, logical access, if you have it, let's say you've got the key, is both necessary and sufficient to get access to intelligible information. So again, geography is not really relevant. The UK government might lose the records of 25 million households, including mine, because the records were stored in some data carrier that was allegedly not encrypted and literally fell off the back of a motorbike. Well, you know, the fact that this was in the UK is irrelevant in terms of whether personal data might have been compromised. Conversely, as I say, if the data are stored in a cloud computing environment somewhere thousands of miles away, you may not even know where, provided the data controller, as we call them in the EU, is still in control, for example, because the data controller is using appropriate encryption technologies, then it doesn't matter geographically where the copy of the data happens to be. So I think the obsessive ongoing focus on geography at a time when we've really moved online and we are operating increasingly in virtual environments where it's the logical access that matters, not the physical access that matters, I think that focus is now increasingly inappropriate and unhelpful. That leaves a possibility, I suppose, a kind of intriguing possibility that instead of looking at jurisdiction in old-fashioned geographical terms, we could start talking about virtual jurisdiction in terms of, well, who really has control over data, in particular cloud computing environments. That is a debate that is just beginning. I think it's a very interesting one. It's by no means going to be easily solved or easily implemented, if indeed there is an appetite for doing it, because when you look at different types of laws, intellectual property laws, defamation, restrictions on certain types of content, data protection laws and so on, the rules are not consistent in the way that they work on a cross-border basis. So there's a lot of work to be done if you really want to develop a model based on virtual rather than physical jurisdiction. But I do think it is worth discussing further. And finally, I can't let the opportunity go by, as in a previous presentation, of telling you about how you can find out more about cloud computing law and regulation. And I want to draw attention in particular to the ongoing work of the Cloud Legal Project in the Centre for Commercial Law Studies at Queen Mary, University of London, and also to the newer Microsoft Cloud Computing Research Centre, which is a virtual research centre, appropriately, which is jointly staffed by computer scientists from the Computer Lab at the University of Cambridge and by lawyers from the Cloud Legal Project at Queen Mary, University of London. You can easily find us on the web, and I would encourage you to have a look at our materials and to give us any feedback you might have. And last but not least, I don't know when you could see the movie, but you can buy this book today. You can buy it online. You can hopefully buy it from a decent bookshop. Cloud Computing Law. It contains the essence of the first 6 years of research of the Cloud Legal Project. And it tells you a lot more about what cloud computing is, how it works, what it means in commercial and regulatory terms, with very detailed analysis of cloud computing contracts, data protection issues in the cloud, governance of the cloud, including things like law enforcement access to data in clouds and many other issues. So thank you very much indeed for watching this presentation, and goodbye for now.